Hi, I'm David Marchant, the founder of OffshoreAlert, which investigates participants in high-value cross-border finance with an emphasis on high-confidentiality jurisdictions. Our specialty is exposing investment fraud while it's in progress. Enjoy our content.
Hello, everybody. It's a great pleasure to be here this evening. My name is Steele of Orbis Business Intelligence, and I'm being joined on the panel this evening by Mark Stevens, a lawyer from Howard Kennedy, Carole Cadwalladr, a journalist from The Observer, and Brittany Kaiser from the US, who everyone will know was previously involved with Cambridge Analytica and is now an advocate for data protection and so on. We wanted to discuss a very important topic this evening, which is the exploitation of defamation and data protection laws, and in terms of lawfare, as we call it, which I would define as the exploitation of laws by bad actors to suppress freedom of speech and public debate and deter legitimate investigations and accountability in the public square. I wanted to make a couple of points just before we start off, which is that all of us on this panel obviously cherish the rule of law, which is effectively absent, of course, in many of the jurisdictions that we work on and investigate. We also accept the sanctity of personal privacy and the right to protect reputation through law. However, the core of our argument today and the debate we'll have is that bad actors and their enablers are now exploiting weaknesses in our laws, in English laws and other laws, to stifle enhanced due diligence investigations and debate. And of course, we all know how adaptable these actors are, and the way it works in countries like Russia and China, of course, is through fear and through intimidation. And the same actors that practice those things in those countries are very adept at using skilled lawyers, expensive lawyers in our own countries where the rule of law is strong and freedom of speech exists to achieve the same objective. I think we would like to concentrate in this session on several aspects of English law, although Brittany will come in on international perspectives from the US. And in particular, I wanted to focus on the GDPR Data Protection Act in the UK. Carole, I think, will talk about libel law, and Mark will talk about both those, and also judicial review, which comes into this debate, I think. So in terms of the Data Protection Acts, obviously we had the original Data Protection Act of 1998, and subsequently the GDPR being brought into British law, English law, in 2018. And so I'm intending to draw upon both my own experience recently of dealing with these laws and being attacked under them in the UK, but also I've canvassed opinion of peer groups and peer businesses in the industry, investigative industry, to find out what their experience of this has been of late. I'm not addressing this as a lawyer, this issue. I'm addressing it as an investigator and an intelligence practitioner. And the GDPR and the DPA are most relevant, I think, for business intelligence firms because they deal with issues where no publication is intended. Libel law, of course, depends on publication, which is more in the realm of investigative journalism as opposed to business intelligence work. And that's why I wanted to deal in particular with the GDPR and the DPA. So it was quite clearly the intent of the framers of these laws that they were designed to protect, if you like, the privacy of the man and woman on the street, to protect their medical records being sprayed around and biodata on their families and so on. But the fact is at the moment that the only people legislating or litigating, in fact, on this tend to be dubious public figures who are trying to avoid, in my view, scrutiny of their activities and their behaviour. The other thing to bear in mind, I think, with the DPA and the GDPR is that they have very long statutes of limitations. It's 6 years for the DPA for any activity or data gathered before 2018, and 3 years for the GDPR, which came afterwards, which of course is much longer than libel, which tends to be only 1 year. And one of the key issues, I think, for investigators that comes out of this is what's called the category of special personal data. Now, clearly, where we investigate investors and foreign businesses and foreign entities, foreign actors, we are looking for any evidence that they may have committed or suspected of committing criminal activity or the likes, which under this act requires a much higher standard of proof and processing than normal personal data. So we're immediately taken into this area of special personal data. And the key challenge, of course, that comes to us all is through subject access requests. That's the first port of call for the people who are in the reputational management industry, which is on the other side of the fence. And sadly, these things can be sprayed around by wealthy bad actors whenever they want to try and uncover investigations. You know, for example, when you take part in a bank onboarding process as a client, or when a decision has gone against them. And in recent times, as a BI firm, one of my peers described this as like a game of battleships, in which they just fire out a number of shots, see if they actually hit a BI firm that's been investigated on a sort of speculative basis. And to be honest, even if they only reveal the fact that a BI firm is working for a particular client or a bank, that's very damaging to the reputation of the firm and its position in the market. So BI firms generally want to work in confidence and unseen by the targets they are investigating. And this is another problem area, and one Mark may wish to comment on. But my takeaway from a case we fought in the English courts on DPA in March was that unless you have a specific exemption, and the obvious ones are national security or legal advice, you may be technically obliged to inform the subject of your investigation that you are investigating them, which of course completely defeats the point of the investigation. That's an area of law that hasn't been teased out properly, as a lot of this is, in fact. The fair processing of requirement also allows bad actors to try and uncover sources, clandestine sources, sensitive sources. And there's no way, for example, that if you are doing an investigation on a Chinese actor or a Russian actor, that you're going to be able to bring your sources and put them in the dock in the court to defend the fair processing principle of accuracy. So what has our experience have been of late? So another issue has been that the GDPR and the DPA have been used as a means of gathering intelligence and counterintelligence by bad actors coming from countries like China and Russia, and to try and uncover the sources of collection and to chill and deter other sources of collection from coming forward, which is obviously a key objective both of the governments of these countries and of the leading sort of business figures in them. In addition, the GDPR and the DPA appear to be used as a means now of a sort of quasi form of discovery, we'd call it, or disclosure. So in other words, if you want to try and sue a business intelligence firm or investigator for an investigation they've done and you need some shrapnel to be able to fire at them, one way of trying to smoke this shrapnel out, so excuse my mixing of the metaphor, is to in fact launch a subject access request or action under the Data Protection Act.
I mean, one of the things about that, Chris, is that, you know, I'm a lawyer, expensive lawyer, I hope, who runs both sides of the street. Sometimes I'm asked to act for investigators to justify, or indeed commissioners to justify, but there's always two phases to this, and sometimes I run the defense side. But what's interesting is that we always use subject access requests as a sort of skirmishing tool. That's how we gather the basic data, the basic intelligence, before we have to start actually pinning our colours to a legal mast. And so, of course, that's part of what we're doing. But if you start seeing subject access requests coming in, they will be coordinated, they will have amendment, and you should know that's phase one. That should be the red flag for you. And that you should have been taking legal advice earlier, but this is the time that you must take it, because otherwise you can be committing criminal offences. And so it starts to they've started to raise the stakes here, which is a real problem.
And also, I think, even though this legislation existed from 1998, it's only being applied in the last few years, in fact, to business intelligence firms and to investigative journalists.
Yeah, and also PR firms, interestingly, because invariably, if you're doing a hostile takeover, there'll be a PR firm, and they are also getting it. Now, there is protection here, so you can justify gathering data on a basis as long as you have gone through a process and documented it. So there's a sort of line of people who are at risk here. So you've got the commissioner who wants the investigation done. You've got their law firm who's going to retain under legal privilege the investigator, and then you've got the investigating firm as well. And so what you need to be doing is to think really carefully about each stage, because you're going to need to have deniability, but you're also going to have to make sure that the instructions and the authorization are signed off. So before a company engages a private detective, they should have advice from a lawyer that it's justified, that it's warranted. And then once they've got that, they should then use the law firm, use the investigator. But the investigator is going to want to know what kind of indemnity they get, whether it's a civil or a criminal case that comes against them. And this is the way in which the law firms for the bad dudes are actually leveraging things, because they're starting to come at you with criminal actions. If it's a fine, the client can pay that. But if it's a criminal conviction, you pay that.
Exactly, and we'll come on to compliance in a minute, because it's a very, for a small investigative firm, it's been operating for many years. It's quite a laborious process. So I'm just pointing up some of the things that we've noticed out there on the battlefield, as it were. So one of the other things that we're seeing, I think, is what you might call hack and leak operations, and that's very interesting. The degree to which a hack and leak operation, a deniable one, can make a company vulnerable to data protection action, even though in the past they have worked legally and under certain protections, including legal privilege, which obviously is undermined by such an operation. The number of, I would argue, and I'm sure most peers in the industry would argue, the number of attempted hacks and the number of attempted cyber attacks on companies like ours have absolutely mushroomed in recent years, and they've become extremely sophisticated. And you've got the whole range from people chancing their arm to state level actors. But the fact is that once information is out, then it becomes part of the game, as it were, part of the battle. And one of the things we've suffered from in our company of late is actually people publishing stuff out of Congress in the US, where they've obtained information from US government departments that was formerly classified or protected. And willy-nilly, they have just decided to publish this material, put it out there in the public domain, which creates a potential vulnerability under retrospective data protection actions. Something that we've spotted and is
and of course they're doing that for a different reason as well, because if you can get it read into Hansard or into Parliament, in some parliamentary record somewhere, you get absolute privilege. So you make the information which is put out there absolutely libel proof.
And the other thing is that we've got an issue which hasn't been fully resolved, of where you transfer data on an individual to somebody, a client or a consumer, in another jurisdiction that is outside of the area of the GDPR, notably America, of course, being the obvious one. But any jurisdiction like Australia or Canada or America or whatever would potentially come into this category. And as far as I'm aware, the vulnerabilities there have not been resolved for investigators. I can't see policies that companies have developed which properly deal with that question. So you don't want to be only orally briefing clients in America and so on with genuine investigative requirements, because the GDPR doesn't make it clear whether you're liable or not if you pass them something electronically. I was coming on to compliance as well, because compliance is a big issue. As I say, compliance for business intelligence firms that have been operating for 10 or 15 years with the IP they've collected now under the GDPR is a big ask. I was talking to one peer in the industry who said, yes, we are gradually making ourselves compliant to this legislation, but if we were to do that overnight, it would take 2 weeks of all our staff working 100% of the time on it, and we can't do that. Indeed, the other thing that comes out of it, of course, in terms of deterrence, is rising insurance premiums and excesses, which is something that happens. It can happen obviously from other litigation, but it particularly happens coming off the back of this litigation, this type of litigation. In our experience, that has happened very considerably since 2017. And obviously, one of the sort of stark things, which is I just mentioned, I hope Brittany will address, is why there isn't this sort of legislation, why it's not regarded as necessary in the biggest market of all, which is the US, and how that sort of affects investigations over there, which you can come on to hopefully a bit later. So in terms of what we're sort of up against at the moment, one of them, of course, is loss of IP. So an investigative firm will gather material on a target or a subject, and it's obliged, once it's completed its investigation, to destroy that IP, which is a quite a big hit for us, given the amount we invest in these things. Report writing can be based purely on corporate activities and behaviour rather than individuals, which effectively circumvents the GDPR and the DPA. But one of the problems there is that in many of the jurisdictions we're looking at, like China and Russia and so on, there is such an interface of individual oligarchs and others with these companies that it's impossible to investigate them or to come to any clear conclusions about them without touching upon individual behaviour and individual reputation and so on. I mentioned verbal reporting only to clients. That's not very practical. It can work on occasion, but it's not really very practical. And I would argue that, and this comes into libel law as well, and it's something that I know does exist in the US because we fought a libel case in the US, is the public figure defence, the public figure sort of threshold. So in other words, because of their wealth and because of their ability to enter the public debate and because of the fact that they welcome a public profile, a lot of the people that we investigate have to prove to a higher level, a higher standard, a tort or an offence than the ordinary man in the street would have to. And that, I think, is a really critical thing, both in that's missing from this legislation, but is also, an issue with English libel law in particular, which no doubt Carole will talk to. And the other thing was that, there's a contradiction at the heart of all this, which is that whilst, say, the British government is very keen to tighten up regulation and to tighten up due diligence and to encourage businesses to conduct proper investigations of potential clients and existing clients, on the one hand, the legislation that's coming out on data protection, I would argue, actually makes that much more difficult, and there's a clear tension involved in those two pieces of legislation. So that was really where I got to with my points on this, and I think it will become a growing issue in the business intelligence world and the business intelligence sector going forward, because those who have cottoned onto this and realise that it's a good proxy for libel law and it's a good way of probing and deterring investigation, it will only grow as an issue to address. And as I say, my own impression from talking to peers in the industry is that few, if any, companies in this industry are fully compliant with these laws, and indeed some of the laws are quite vague in terms of what you need to do to be compliant with them. So that was the point, really.
Mm-hmm. Thanks, Chris. Shall I come in next?
Yeah, please do.
shall I riff off a bit of this in a less prepared fashion? I have to say, we were complimenting Chris on his amazing preparation earlier, but I mean, I think it's very true. Is that sort of my experience has been that defamation and privacy have both been used equally abusively in terms of trying to chill investigative journalism. And there's sort of, I think there is a really growing body of evidence that both are being used abusively, and not just by the kind of key thing about this is that Britain is becoming a sort of vector for bad actors, essentially, to use our particular laws to chill investigations in their own country. There was a really interesting bit of research done earlier this year which showed that I think it was something like 60% of investigative journalists throughout Europe had faced defamation legislation which was running through London, even when, you know, the stories had very little traction there, or the people weren't based there. They were still finding ways to use our defamation laws to chill investigations in you know, a whole host of other countries. And I suppose, I mean, I'll just tell a couple of stories perhaps, which is of my own experience, and which is that anyway, it was really you know, through 2017 and early 2018, it really felt like touch and go as to whether we would be able to publish this huge wealth of material that we had on Cambridge Analytica. And we had an escalating number of legal threats from the firm. And at the same time, we also had privacy sort of, so actions taken under privacy legislation as well. So I think it was something like it was either the first or second article I wrote about Cambridge Analytica. We had a big legal letter from Cambridge Analytica, but we also had from Sophie Schmidt a legal letter, which is, I don't know if you're familiar with her, but she's the daughter of Eric Schmidt, who is the chairman of Google. And he very famously said that privacy is dead. That was his slogan. And I'd put Sophie Schmidt in the first paragraph of my article because I discovered that she had been an intern at SCL, the parent company of Cambridge Analytica. And she was actually the person who'd suggested that they get into data. And she'd suggested that they meet with Palantir, Peter Thiel, who of course is a big figure in the sort of Trump orbit. And I had two different emails from two different people which sort of stated all of the facts on these. So the facts weren't in any doubt, but at the same time, so from this article we published, we had this pre-action letter from Cambridge Analytica, and at the same time we then had a letter from Sophie Schmidt. And what was sort of, what was so devastating actually was that with the Sophie Schmidt thing is that we had all of the facts, we had the evidence. The lawyers in the letter admitted that all of the facts were true and even gave us more details, but threatened to sue us on the basis of it. And essentially within the paper it was, well, actually we can defend this. They probably won't win if we go to court, but that is a risk. But, it might cost 20 to 30 grand. And considering that we're already facing this other legal action, we can't, there's just a real question about where we spend our money. So we ended up taking her name out of the article, and which is something that I really regret. And it's still there on the Wayback Machine if you look at it. But I think it just sort of, it does show you the sort of, I don't know, the obstacles and challenges really of publishing anything in Britain. And it was very much a sort of escalating threats we had from Cambridge Analytica. In the autumn of 2017, it was something like a 35-page legal letter we got from them. And, I kind of look longingly across at America in terms of the sort of publishing climate there, but that doesn't help me. I mean, you know, I'm being sued at the moment on the basis of a talk that I gave in North America, which was with a North American media company, and I'm being sued individually on the back of it. So
in England.
In England, and the media company is not being sued. So it's, you know, it's. I mean, I can't actually talk about that case at the moment because it will be used against me in a court of law. So it's kind of, you know, it's a sort of, it feels like a very sort of catch-22 situation.
But that's kind of the bully boy tactics which the claimant bar, the plaintiff bar uses, because what they're doing is they're cutting you out from the pack. So they're not going for the people with deep pockets. They're going for what they perceive to be the most vulnerable. And often that will also not just be an investigative journalist, but it might be an individual in an investigations practice, or it may actually be the investigations practice. They're not going to go for the deep pockets because what they want is a win by bullying rather than a win at law. And what's interesting and the development that we're seeing is that, you know, we as lawyers who defend the press day in, day out are used to reading the stories and the investigations that you produce, Carole, but we know how to kind of protect them against libel and to privacy. And so what the creative end of the legal profession is now doing is it's starting to move away to laws of what might be described as general application. So laws of harassment, laws of the Gdpr, which of course is intended for a completely different purpose. And they're trying to shoehorn those bits of legislation and expand them to be able to intimidate and chill. And so that free speech suddenly becomes expensive speech and so expensive that you can't afford to defend yourself. And they hope that they'll win by default in that way.
Yeah, I had a similar experience with that. I also received a legal letter from a particular Brexiteer saying that I should stop releasing evidence of his own data violations because he would sue me under GDPR for releasing his personal data, even though it was evidence of cases against him, which he had been shown to be guilty of those violations. So it's rather complex to have bad actors use laws that are meant to protect individuals against the individuals that are trying to uphold these laws for the sake of the greater good. We've also seen that in the United States. For instance, as soon as the California Consumer Privacy Act was enacted, Facebook's lawyers came out and said that Facebook would not actually be regulated under CCPA because they legally did not sell or transfer anyone's personal data. So to have the first landmark privacy law in the United States, according to Facebook's lawyers, not apply to them was a massive disaster in terms of, I suppose, the drafting, but really in terms of, you know, a bad actor that has been shown to be guilty of numerous data protection violations, being able to use that against the people who are so badly trying to get them to act ethically, right?
I'm interested, Mark, can I ask you a question about the ethics of the lawyers involved? Because
we have an ethical bypass at birth, otherwise we couldn't be lawyers.
But most, you know, one of the most egregious cases are these terrible actions which are still being taken against Daphne Caruana Galizia, even though she got blown up and murdered by a bomb. Her family is still being sued for libel. I mean, I despair at that, I have to say, and that is British legal firms who are still acting for those parties.
Yeah, I mean, look, I think that what London lawyers, I mean, let's start with the beginning. London has become the libel capital of the world. Crooks and brigands jet in to launder their reputation in Court 13, the libel court, in order to get them a vindication that they couldn't get in their own country, to try and get to a country where witnesses are no longer compellable. So the people with the dirt on them still live in their home country. So you're seeing sort of oligarchs and, you know, rich sheikhs coming in, and they know that they can prevent those witnesses who've got the dirt on them coming to London. So effectively, you have to be a moron in a hurry to lose a libel case in London if you're a claimant. And that's why 90 to 95% of cases are won. But the motivation behind them is often totally reprehensible. Of course, the theory is that libel is about vindication and exculpation of your reputation, a stain on the family escutcheon. But in reality, it's so often used as a method of intimidation, as an attempt to chill not just investigative journalists, but NGOs and private investigators, people who are gathering information in the public interest. Now, the European Court of Human Rights and also the European Court of Justice have set out strong defences for people who set out to provide information which is in the public interest, and it's constantly being pushed. But of course, you can only win those cases if you go to battle. If what happens is that the bean counters say, look, we're going to have to do some kind of sly settlement here because we can't afford to stand on our principles, they're too expensive, that the expensive speech has come along, then in those circumstances, the bad guys win.
Can I, as well, Chris, actually, I've got a question for you, which is an extension of that, which is one of the things that I've really noticed and personal experience in the last few weeks even, is the way that legal action is used as part of a kind of wider disinformation campaign, essentially. And I mean, you have been very targeted in terms of this right-wing fake news network, essentially. And I just wondered what your take on that was, where you feel, because you've had these, you know, you've spent a lot of time in court in the last year. Have you noticed the way that that fed into this kind of narratives, which were then spread about you by this sort of, you know, very partisan media?
I have to be careful what I say on this, otherwise I'll spend the whole of next year in court as well. But no, I mean, I think it's a multiple sort of attack, because it's about putting you out of business. It's about making you uninsurable. It's about sucking up all your time and effort. It's about trying to expose your sources and your clients. It's a whole scale attack. And, you know, the things we've seen in the last year, we've seen some extraordinary things in our cases. In one case, we had live streaming of the proceedings of the trial into Russia. But on a sort of a more basic level, you know, I spent in the libel, in the Data Protection Act case we fought in March, I think half of my cross-examination was about our sources and about my previous career, neither of which actually were directly relevant, I would argue, to the case. But it was an example of how other people and other objectives were commanding the action that was being taken, and not the law. And I think it's the experience of having been through both a DPA case and a libel case in the last year in the English courts. We actually won the libel case hands down, and the DPA case we got flesh wounded, which is another point that Mark might want to address, where you go into court and you win 4 out of 5 things, and then you get caught on the 5th and you end up paying costs. So I think there's all sorts of things going on in amongst this. There's counterintelligence being gathered. There is an attempt, as I say, to put you out of business. There is an attempt that other firms will take note of what's happened to you and will pull back from doing certain work and certain investigations. And as Mark will know, you know, in the legal community here, those that represent the bad actors know all this full well. And that was what sort of informs their strategy.
Oh, sorry, Mark, is that you?
Mark, go.
No, I mean, I was going to say that this is absolutely right. And of course, that's why people are pressing into service. So one of the latest trends that we're seeing sort of breaking as we speak is the use of prevention of harassment. Of course, if you're going to investigate somebody, you're going to build a file on them. There may be physical surveillance. And so as a consequence of that, they're now bringing both civil harassment claims, but also criminal harassment claims. And of course, the purpose of that is that you've got problems, because as soon as you decide to surveil somebody, it's notionally upsetting if they find out about it. It's going to be harassing and causing them alarm. So you're entirely on the back foot jurisprudentially, because you then have to say, well, why was it justified in the first instance? And so we get to this sort of multi-stage decision-making process, which we as media lawyers are used to with, for example, secret filming. So if the BBC wants to do some secret filming, they have to first of all come up with a justification that there is prima facie evidence of serious moral wrongdoing or some measure of criminality. And if you've got that, you then have to determine that the only way of getting evidence, the only way, is through secret filming. And then if you document that decision, you can then go and make the secret filming. But you then have to make yet another decision, because when you review the material, you then have to decide, is it something which I've caught the evidence or I haven't? If you haven't caught it, you're obliged to junk it immediately. If you have caught the evidence of wrongdoing, you then go into an analysis of whether it's in the public interest or sufficiently in the public interest to put this into the public domain by publishing it in a report, or putting it into a private investigator's report, or putting it into an investigative journalist's report. And so there's this kind of multi-layered decision. It's bureaucratic because you've got to document everything. And if you don't document yourself, you're creating vulnerabilities. And so we are becoming far more process driven. We're increasingly asked, both in-house media lawyers, but also out-house advisors are being asked to help people document the decisions and be able to say, well, look, we took legal advice on each of these phases before we went and invaded this person's privacy, before we harassed them. But so the information you may get is utterly true. So we're talking about truthful, discreditable information, which you may not even still be able to publish. And so that is the sort of game that's being played, and the judiciary have gone along with it, particularly in London, but also elsewhere in Europe particularly. They're starting to say these things are invasions of privacy. And what we need to do is to start to push back against that tide, because they need to understand the public utility, the importance of investigative journalism, of private investigators and non-governmental organizations. And we had a kind of example of this. You talked about notifying, Chris, of a subject of inquiry. This started in the charity sector. So what was happening was that people who were identifying high net worth philanthropists were being told they had to, before they built a profile on them to approach them, they had to notify them that they were building the profile. Well, that's an arrant nonsense. And eventually the Information Commissioner said that's an arrant nonsense. And of course, you don't need to do that because it's a legitimate purpose. But nobody's got to that point with investigative journalists. Nobody's got to that point with investigators, and nobody's got to that point with NGOs.
Can I sort of segue a bit here by asking you, Mark, firstly, what you think of the public figure level of proof or whatever threshold, and then moving on to Brittany on the United States in particular and how that fits into this framework.
Yeah, look, I think that the American standard, which is the public figure, the actual malice standard, which effectively guarantees freedom of speech and even the right to get it wrong, as long as you weren't malicious and deliberately averting your eyes to something. But that is a very protective free speech standard, and nowhere else in the world other than the Philippines, because of Subic Bay, has that same law. So effectively, the balance between free speech and privacy or reputation that has been struck in every other country on the planet is one much closer to the English law. And that's not surprising, because it was part of our law. We ceded it into the Commonwealth, the British Commonwealth, in days of empire. And as a consequence of that, that sort of standard is the sort of pervasive standard, but it is weighted in favor of the person who is being investigated, of the person who's done wrong, because they are presumed to be fine, upright citizens unless we can besmirch their reputation with good, decent, hard evidence. And that's always a tall order, particularly when you're fighting subject access requests and they're tailoring the evidence to meet it. So it's a real challenge that's being put in here. And there's a lot of expensive legal brains on the other side working out how to make it as difficult as possible for us.
Is there any reason, though, why we couldn't have a public figure statute in the UK in our laws here that we're talking about?
No, there isn't. But repeated governments have pushed back against it. So I was one of the people who was consulted about the last libel reform in the UK. I was a panel of lawyers who specialised in this. And I was a lone voice in pushing for a higher standard and greater protection of free speech. And what's interesting is that the advances that we made in that Defamation Bill and Defamation Act have actually been eroded by a hostile judiciary who don't want to embrace the reform. They don't want to protect speech. And that's always a fundamental problem in the UK. And I think more pervasively, but I don't know, Brittany, what's it like in the US?
Yeah, tell us about the US, Brittany, and how this works there.
Now that we're on free speech, that's a perfect segue because especially in an election year, the term free speech has been abused by some of the worst bad actors in terms of data protection in the United States. They're saying that because of upholding free speech, that is why they refuse to block, censor, or remove content that actually breaks other laws that we already have. I mean, we have laws against voter suppression, we have laws against incitement of violence, but yet a lot of that content is allowed to proliferate on platforms like Facebook under the name of protecting free speech. Unfortunately, I guess a lot of the lawyers here haven't spent a lot of time studying human rights law because the right to free speech is not an unchecked right. My right to free speech ends where your human rights begin, and I do not have the right to incite violence upon you or to suppress your vote. But unfortunately, we're not able to enforce those types of laws on digital platforms at the moment. So we have these bad actors using those types of excuses and saying that removing any of that content would be censorship, as opposed to just obeying other laws that we have and making our digital life similar to our physical life, because a lot of the content that is allowed to stay on Facebook would never be allowed to be said by me out loud in a public square, for instance. So I think that is incredibly important. And if we're talking about also bad actors finding other ways to abuse data laws, I think talking about the abuse of civil fines as just a cost of doing business, I would say even more in the United Kingdom than in the United States, because the gravity of the amount that is charged. For instance, in the United Kingdom, selling out democracy for a couple £100,000, which was the full extent of all of the fines that were given in most of the Brexit data protection cases, is extraordinarily low and incredibly shocking. But even in the United States, when we managed to levy a fine as big as $5 billion, we still have the bad actor, the perpetrator, making more money than that on the same day because of the amount of press that the company got over that fine. So when the cost of doing business can include the fine and the legal fees, and you're making more profit off of breaking the law, then there is actually no reason for a lot of big companies that have that type of budget to obey the law. And that is a massive problem. It's why I'm such a huge supporter of some of the new legislation. For instance, last year, Senator Elizabeth Warren introduced something called the Corporate Executive Accountability Act, meaning that if through gross negligence, which has been proven in cases like Facebook and Equifax, if through gross negligence, the executives of the company have allowed a data breach, I was the only expert witness in the first successful case against Equifax. And what we found was that Equifax had let over 3,000 security certificates expire, and basically had left the lights on, the doors open, and the alarm off of a house, right? So that was blatantly gross negligence. So if that were to be the case, then that would be criminal liability, not civil. And I think we really need to start to think in these terms, because too many companies don't have a real incentive to obey the law. And when we're just in the beginning of the creation of data protection laws around the world, we need to be more serious about enforcement, which has been a huge problem with GDPR. And now that we have new privacy laws springing up around the United States, I do worry about enforcement. I've helped write tons of new laws over the past few years here. Some of them have gotten through, some of them we're working on, but we're about to come up with even more data protection problems than we ever thought we would have. I helped write one of the first, the first coronavirus contact tracing data protection law, where we're taking amazing things that we got out of GDPR, such as purpose limitation, and bringing them to the United States really for the first time, and saying that if you are going to collect data for the purposes of public health and preventing loss of life, then you cannot go and share that data with law enforcement for targeting of peaceful protesters, for instance. And now we're about to start writing laws on immunity passports, which are unfortunately probably going to be inevitable over the coming months and years in certain cases. So how do you decide, how do you figure out how to stop people from being discriminated against if they have been sick or been around people who are sick, so that they can still go back to normal life and travel, or go back to their office of business, whatever it happens to be? And how do you stop that data from being used for other purposes? Because right now, no contact tracing. I mean, obviously there have been some good moves in the UK, but mostly around the world, no contact tracing is even regulated yet, let alone the immunity passport. So there's a lot more to think about than what we were having to deal with in 2019 and before that.
Coming back on the whole issue of defamation in the US, having sort of fought a case in that area as well, I'm very conscious of the differences between different states and different federal and courts and all the rest of it. And one of the things that's really shocking is the fact that if you are forced to fight a defamation case in most states and you win, you still pay your costs. I mean, in the federal court in DC, Fusion are having to do that and pay their own costs, even though the case against them is clearly ridiculous. Yeah. And that's going to cost them, $1 million or whatever, just to see off the opposition who've got bottomless pockets. And it's the same.
Lawsuits are a habit for people here, though, unfortunately.
But in areas where there are costs and slap at prize, the strategic litigation against public participation laws, like in the district court in DC, you've got a much better chance as an investigator of defending yourself than you have in the UK. So how does it vary across the states in terms of what you're doing at the moment?
Yeah, of course. I mean, I've been lucky to not be subject to a defamation or libel suit as of yet, but I have supported plenty of other people who are whistleblowers in different industries who have been. And the difficulty is that, as you said, everything is varying state by state. So the difficulty is figuring out where they are actually going to hold the case, where they were when they actually decided to post or publish something, and even worse in the US, like which judge you are going to get and whether they agree with what you're fighting for, unfortunately. So it's been really difficult in the US. I couldn't say it's anywhere as difficult as in the United Kingdom, just because you are more likely to win just because of proof. But I do still think it's a massive issue because of, again, as I mentioned just a moment ago, frivolous lawsuits. It's really easy to silence someone if they do not have the money to pay their costs. So you can serve them and serve them and serve them. And even if they win the case, they might be in debt for the rest of their lives. And that's a really easy way to silence most people, unfortunately.
Yeah, and of course, the other thing about this, Chris, is that because we have these two different standards between, America and the rest of the world, basically, you've got protection. So there was a thing called the Speech Act, which Obama signed into law. It was the only cross-party supported piece of legislation. And essentially it said, if a judgment in libel is not procured by at least guaranteeing the minimum standard, then in those circumstances, we will not enforce that judgment. So I've got a lot of American clients who I just say, don't turn up and play in the UK. Let them get a default order, let them get a judgment, because they'll never be able to enforce it against you in the US. And I advised in the case where that had originally started, a woman called Dr. Rachel Ehrenfeld, and there was a whole load of other cases around that. But it's a real issue. And so in America, we got to a stage in a case in Maryland called Matusevich against Telnikov. And what that was a judgment from the UK for about £1 million. And what they tried to do is to enforce it. And the judgments in the Maryland Court of Appeals said, actually, British libel law is deficient on 14 separate grounds to the protections of free speech that we find important, like the public figure defense, like the actual malice standard, all of those kinds of things. And as a consequence of that, essentially the judgment was struck down and rendered unenforceable. So, you know, it probably tells you how much safer it is to publish something in the US than it is in the UK or elsewhere in the world. And we've seen it for years as sort of libel lawyers. Every time Kitty Kelly comes out with a book, you know, there's the American version, which has got all the juice in, and there's the UK version, which has been completely denuded by lawyers putting allegedly in everywhere.
I experienced that process with my own book, and there are many things that there are many interviews that I gave in the US that I was not allowed to give in the UK, even to British journalists, where I had to be on US soil in order to give those interviews, and things that I was willing to say and publish in America that I just couldn't do in the UK. And that prevented, in my opinion, a lot of my public education and evidence getting into all of the hands and minds that it should have done in a timely manner.
And just briefly, Mark, something on judicial review, which we haven't sort of touched upon much, because I know certainly in some of the investigations we've done here, in fact, particularly for regulators, which is particularly important in terms of you know, the integrity of the system, the financial system. That's been their biggest fear, that the bad actor will take them to judicial review and then they'll either lose because they can't produce their witnesses on the stand or whatever. Could you just say something briefly about that before we finish our time?
Yeah, I mean, it's again one of these laws of general application. So normally we judicially review ministers who make bad decisions that are not compliant with the law. But what we're now seeing is that expensive legal firms are holding that as a sort of sword of Damocles over the regulator, so that the regulator won't actually commission proper investigations which might otherwise reveal the serious wrongdoing that they're supposed to be investigating. So if you can effectively intimidate and silence and stop an arm of state, your regulator is failing. And that's one of the major problems that we're seeing. And, you know, until we start to push back on this in a coordinated way, we're going to see all of these different laws used in the armory of the bad guys with expensive lawyers who really don't care what they're doing. They have no morality attached to them, and they're going to just try and silence all the dirt coming out.
And just very briefly, the judicial review issue, as it were, that you've just highlighted, is it a particular UK issue, or is that also everywhere apart from the US?
For my experience has been that it's just been in the UK. I haven't seen it elsewhere, but I think in other parts of the world, we're seeing the slap problem that you referred to, which of course started in America and has now seeded itself in Canada, in India, continental Europe, and it's really starting to grow in the UK as well. Okay, we're running out of time now, but I'd like to take a moment just to thank Mark, Carole and Brittany for joining us in what has hopefully been a lively debate, and one which informs the way in which investigators are going about our business going forward. So thank you very much for this session,
and good luck with all your various trials and tribulations.
And you all, thanks for all being here. It's been a great discussion.
Thank you, everybody. Appreciate it.
Thanks for watching. Consider subscribing to our investigative news and documents service and attending our events. For more information, visit offshorealert.com.